I was previously president of the family division, and I discovered that the most important part of family work for judges is children. The Children Act 1989 makes welfare of children the paramount consideration. But the effect on children of disputes and separation of parents is usually traumatic and can be devastating and affect the rest of their lives. And delay in sorting out child arrangements can seriously exacerbate the impact on the children. Judges are therefore very concerned about getting child disputes dealt with quickly and preferably come only briefly to court. In the past, there have been efforts to require parents to seek information sessions and mediation, but I thought it might be sensible for our parliamentary group to find out what in fact is going on to some extent behind the scenes in the family division and the family courts. So I went to see the present president, Andrew McFarlane, to find out what are the current initiatives. And the most important is a pilot project called Pathfinder. It is actually a government initiative, much to their credit, currently being trialled in North Wales and in Dorset. It will be rolled out in Birmingham and in Cardiff later this year. The pilot seeks to test a more investigative approach with earlier information gathering and close information sharing between agencies. So this is what goes on. Where parents are in dispute over child arrangements after parting and a Section 8 application under the Children Act is made, CAFCAS becomes immediately involved instead of waiting until a judge makes an order. CAFCAS checks with the police, checks on possible domestic abuse, checks on possible referrals to independent authorities, where necessary to find what risk assessments there are of domestic abuse, honor-based violence and stalking, which is all of which is intended to support the victims of domestic abuse. And they then, this is all intended, as I say, to support victims. And then they come to the judge with what is called a child impact report with the parents present. This focuses on the needs of the child, the core issues for the child and the child's welfare. It is not in any way the core issues of the parental disputes unconnected with the children themselves. The judge sees the parents in court, holds a conversation rather than doing a proper hearing to try and sort the issues. And a very high proportion of parents then go away and there are no further proceedings. And generally, if a hearing is needed, according to Sir Andrew, it's dealt with usually in about 2 hours. And there is then later a review of the court order to check that it meets the needs of the children, not the needs of the parents. There is overwhelming positive feedback. This is a government response in January of 2024, very recent, to 2020 report on supporting earlier resolution of private family arrangements. And in response, the government hopes that subject to findings and evaluations of pilots at the next spending review, this Pathfinder will be rolled out across all the courts in England and Wales. Clearly, it will need further resources for CAFCAS. The president told me that he went to see a Pathfinder court very recently, and he is very enthusiastic. And much to his pleasure, the Ministry of Justice, particularly the Lord Chancellor and Lord Bellamy KC, the Justice Minister in the Lords, share the president's enthusiasm. They all think this is the most important development to improve the ability of the court to engage with parents and achieve a timely resolution of welfare issues. There are also efforts to simplify the language used in family court proceedings, a very sensible idea. The judiciary are naturally very concerned about delays in child cases. One factor is the lack of legal aid, so that most parents act in person without lawyers. Cases are becoming more complex, and it increases the volume of work. There are issues of recruitment and retention in the court system, some inexperienced court staff, lack of courtroom space, resourcing pressures across all agencies, and access to local services. And that goes on. There are efforts to reduce fact-finding hearings, very sensible thing, which are often unnecessary, and better information and mediation to resolve issues without going to court. The Pathfinder pilot, which I personally think is a brilliant initiative, now waits for government resources. The money will have to be upfront, but there will be considerable financial savings when it's rolled out, and in judge time, and in court space, and in all other areas. So I sincerely hope the Pathfinder pilot will become a great success.
You're on mute, Mike.
Thank you very much indeed. That's very succinct. So we now have plenty of time for searching questions. My first thought was, if this Pathfinder is so good, maybe the APPG can pack up. Maybe the job's done.
I think there's still a lot of work the APPG could do, including supporting Pathfinder and encouraging whichever government is in power by the end of the year and the next spending review to say this is a very good use of public money.
Excellent. Right, so over to you for questions.
Can I ask if you remind me which courts that is presently working in the Pathfinder?
Only in 2 courts at the moment. I think it's North Wales and in Dorset. It's going to Birmingham and to Cardiff.
Right.
Later, so there will be 4 courts before the summer, 1 in April and I think 1 in June. And then we wait on the next spending review for getting it rolled out across the country.
Thank you. Okay, over to you, Alan.
Yes, Baroness, I wanted to ask a question about interim arrangements where domestic abuse is raised as an issue, because even in the Pathfinder model, which I'm very supportive of Pathfinder, but of course, in a lot of cases, it will flag that there have been domestic abuse allegations, which may or may not be true, and which may or may not be relevant to the children's welfare. But often that process at the moment of sorting out what the facts actually are and whether they're relevant to welfare can take 2 or 3 years at the moment. And at present, it's actually quite rare for the so-called non-resident parent to have any interim contact at all, even supervised, which I think it perhaps wasn't the case at the time when you were president to the extent that it is now. I think that's been a change. And a lot of it is to do with the way that PD 12J has ended up being interpreted in practice. So I wondered whether in the Pathfinder courts, where domestic abuse is raised as an issue, what consideration is given at that first hearing to whether or not there can be safe arrangements in place to keep the child's relationship with the parent alive, with both parents going during a period, the period of time which even in the Pathfinder courts, I imagine it's going to take 6 months, 7 months. I don't know. Hopefully, a lot less than the 2 years it's taking at the moment, but it's still going to take quite a lot of time.
Well, as I understand it, and I know all this secondhand because I learned it from the current president, but what happens is there is an immediate referral on a Section 8 application, that's a child arrangements application, as you all know, to CAFCAS. CAFCAS, before it actually produces its impact report to the judge, actually gets in touch with all the agencies, including, of course, the police, the domestic abuse advisors, the local authorities, and so on. Particularly, I expect the social workers. And if domestic abuse is an allegation that is being made, that comes into the impact report. And the judge will then have, at the first meeting, an impact report setting out what the allegations are. How the judge deals with that, I haven't actually been told. But the fact is, I've no doubt that if the allegations do not appear obviously to affect the children, then he would try and make some sort of order that would permit the non-resident parent to see the child. That's what, having been a judge, I would expect to happen. If, on the other hand, the domestic abuse is extremely serious and has put, for instance, the mother into hospital or something like that, then I suspect they'd have to go through a fact-finding hearing. And that, of course, adds to the delay. But there will be a lot of cases, which I've certainly had, on domestic abuse allegations, where the children have actually been marginal. I mean, I've also had cases where the children have sat in the kitchen, absolutely terrified, while dad was beating up mummy in the living room.
That's great. Nick Fletcher, Honourable Chair.
Hello there. I'm in the library, so unfortunately I'm having to be a little quiet. Thank you for that. That was it was very interesting. You talked of costs. I just wondered if you'd got any ideas of indicative costs. Obviously, you also talked of savings as well. So money always talks. So it would be good if we had some idea of the actually initial costs, but then the savings. Do you have anything on that?
I don't have anything. It's a question I should have asked and I didn't. Obviously, not only CAFCAS, but I suspect there will be other costs up front. My experience of, if you have a good system like this, is there will be very considerable savings. I think it might be important for us to know something about it. What I'll do, if you as chairman agree, is write to the president and say this was raised. Can he help, or should I go to the MOJ?
Luckily, Sir Andrew is coming to speak to us next month. So.
Well, I'll alert him on this.
Yes.
It may be that he doesn't have the figures, and it may be that he needs me to ask the MOJ. I can't ask Lord Bellamy at the moment because he's away sick, unfortunately.
Okay. Right, Ian Maxwell.
Hi, I can add a little bit to Lady Butler-Sloss's points, because we actually produced a report recently called Learning from Abroad. Oops, sorry, I'm trying to get the light right. Which, given that we are speaking from Scotland, so this is a foreign system to us in terms of the family courts. There is a domestic abuse, stalking and honour-based violence assessment, a DASH assessment, conducted by the CAFCAS at the same time they do the child impact report. So definitely they have built this in. And there was the Nuffield Foundation had an interesting talk for two of the judges who'd been taking part in the pilot. And I remember them talking quite a lot about that. But I think I'd agree, it is a really welcome, both quick, but also investigative rather than adversarial process, which seems like very much the way to go. But I would suggest that you still need to do this work, the APPG, and in particular, look at what is being done to support parents once they separate before they reach anything near court, because I think that is another major gap in the system. And if one could reach, let's say, 60 to 80% of parents at a very early stage, you could then avoid anything going near court, which would be massive savings for the system. So I think in looking at changes, one needs to look at both court and before court.
I think Sir Andrew is extremely supportive of that and is very much hoping that other aspects can be put in to catch the family very early once the parents are separated.